Still on Chairman Wontumi, Martin Kpebu said Chairman Wontumi be just 13 years in jail. What is the explanation? What we no so no bi Ghana is working again, but onya 7 to 5 years there. Yema Wontumi pardon na. Ebeye ye ba nenti ase yema Wontumi pardon no so wachirem. And I love his submission and some of the things he's bringing to bear. I think that is very refreshing. And no because oh asana I'm sad for you. Yes, I'm sad. Say nipa there. And be you kan no we there ye life matter senti mu me nyai me kan there be me dimiti ball me wardrobe. No can say I'm in my bedroom. My studio is my bedroom. Ti me ba na miti ball me wardrobe. Nti na say me nya kakra nti mu fancha me. Aha enye esu. Me su asa ka me catch plane crash this year me su yese mo amu yet. And I don't have any difficulty accepting that, but I hit my head nti mu fancha me. But Martin Kpebu they very interesting explanations at the aba, and also lot of angles out there. But what say he's happy with the verdict. The reason is that Martin Kpebu is part of the media coalition against galamsey, headed by engineer Kenneth Ashigbe. Lot of interesting perspectives are on the matter. Why is Martin Kpebu saying that Wontumi be 30 years, not 20 years in jail? Then to know kase yema Wontumi presidential pardon would be 5 to 7 years. And yema ninye bibi then the woman medinya bro in this video. It's make also be subscriber. My most subscriber no click the notification. The video be to mabu and what my you will certainly have a comment. Feel free leave that comment in the comment section. We are Mesro Sobeko Goldberry construction method and episodes in Masasan Kratasem. The documentations related to your house and Goldberry. And the baby say you manage at the amount. We na sana mekano a flat victim. Now he will be very innovation at a very convenient, cheap rating. So I could Goldberry baby say you manage at the amount. Let's not waste time. We all know what has happened to Wontumi today. The breaking news coming in. This is what Martin Kpebu said.
It's a sound decision, without doubt. I was in there, at least I listened to the judge for at least 1 hour. I was in there for more than 1 hour, but I had to go do my other cases. What I heard was very sound. Kudos to Justice Kokuvite. I'm sure she'll be one of the next candidates to go to the Court of Appeal. She's been in the High Court for long. So we hope President Mahama will look favorably on her and send her to the Court of Appeal. She's done a good job. Look, it takes bravery. It takes a lot of bravery to render this decision. We don't, so we should look at what can be done to also show the judge appreciation. Not everybody can give such a decision because when you go, sitting in court there, say, hey, is that the Ashanti regional minister? Listen, you see, I'm even saying minister. You see, Chairman Wontumi at a point, they were calling him what? He said he was the governor. Though there was a minister, he said he was a Ashanti governor. And you know what that meant. You see, so on the ground, he wielded a lot of power. And yet here, today he was in the dock and Justice Audrey Kokuvite was reading the judgment. Then I felt that, oh yes, Ghana is working again. Ghana is working again because this is the same kind of case that under the Kufuor administration, we presented our petitions against Chairman Wontumi as far back as October 2022. 2022, more than 2 years before Kufuor left office. Yeah, the CID boss at that time, and Kofi, and then IGP, they were doing kukwasa, like so to wait, delay, because of Chairman Wontumi's influence. So you see why we had to change the MPP so that the system would work. Because as long as MPP remained in power, Chairman Wontumi was not going to be brought to book because he was governor of the Ashanti region, governor. And today he's been showing his real size, right? So it's good. It's a good judgment by all standards. But in the legal system, you can expect that he's going to go on appeal, etc.
Absolutely. What do you say to those who think that the judge, Kokuvite, should have waited for the Supreme Court interpretation that Samuel Atachia was seeking or on the minerals aspect of the Minerals Act that was being used in this case?
Well, that would have taken the case too long. It would have taken too long. We don't know when the Supreme Court will do the interpretation. So that was way too long. Even the first question is, as to whether the Supreme Court would even accept to do the interpretation, nobody can tell. You see, when you do a reference, what Atachia's request is that send it to the Supreme Court that this and this and this require interpretation. Now, As to whether the Supreme Court will agree, we will not even know. So it's not something like Justice Kokuvite could take it to the Supreme Court, let's say a week. And don't forget, 31st of July, next week, Friday. That's our last day. We are going on vacation. So from 1st August to about 10th October, these kind of cases, the type that involve giving judgment in criminal cases, people giving evidence, Supreme Court sitting, cannot happen. So the Supreme Court doesn't sit from 1st August to at that time in October. As I said, let's just say practically by somewhere around 10th October, the Supreme Court would not work. Remember that even the year we're clamoring that the Supreme Court should work during the vacation to take care of this Daniel Yao Domlevo case, where we thought that Akufo-Addo had sacked him because they didn't want Domlevo to catch them stealing. Even that one, the Supreme Court didn't sit. The Supreme Court didn't sit.
Right.
Much less at this one. So what I'm saying is that the timelines simply didn't favor Atachia's request. The timelines didn't favor. In any event, and the judge also said that she has done her own interpretations. So what will happen is that now that the decision has been rendered, by all means, they will disagree. So they can file an appeal, and then they can file for appeal, what do you call it, pending for bail. They can also file for bail. They can
right. So Martin, what I'm trying to understand is, I mean, a number of times we've heard that, you know, the wheels of justice grind slowly, and I hear you make the case on timing and the fact that the Supreme Court's interpretation could take a really long time. What would we rather have, that we have this done well and done right, or we rush in getting to a decision as we, you know, as it may be, it may not be the case, which is why I'm asking, right? Was it a legally correct step that the judge had taken in this case?
Yes, on the facts of this case, yes. So I'm very mindful of that policy. Yes, even the courts also adhere to it. That's why justice grinds slowly. That we would rather take our time and do it right than to rush and to abuse somebody's human rights, etc. Yes, that's not lost on the court. And almost every lawyer who means well for this country, we invoke it all the time. But on the facts of this case, I don't think much injustice has been done. You see, when you listen to the judgment, the evidence so far, Wontumi doesn't deny, right? It doesn't deny that he gave the land. But he is saying he gave the land as a concession to Henry Okum and JC Apia to do reclamation. So let's go to the facts. So in order to determine whether there is danger of abuse to his rights, you look at what really happened. What really happened is that the forest has been degraded, forest destroyed in mining operations. And what's the response? The Wontumi says, oh, I only gave it to him to do reclamation. But the person you gave it to says, no, I did mining on it. Mining. So the one who was in the center of it, the one who undertook the illegal mining, is saying that no, you gave it to me to do mining. So it's mining I've done and destroyed the forest. And which means say, no, I only asked you to come and cover up. That's do reclamation. But you know, where Wuntumi's case falls apart, as shown in the analysis of Justice Kokuvite.
Very well, and just a quick tracking back of what we have discussed already. I've just been told that there is no case yet at the Supreme Court. Rather, Samuel Atachia, who is counsel for Chairman Wontumi, had indicated an interest to do so, or a desire to do so. So, Martin, I guess that we are back to the point that indeed it was a sound legal decision that was taken, and no legal misstep had been taken in this process at all. But looking ahead, you've talked about how there could be other options for them post this decision. What could be there for Chairman Wontumi after this decision?
Good. Now let's correct. Maybe the way the person didn't hear well. So let's correct what's happening. Atachia brought an application, to the court that there is Justice Kokuvite should send the matter to the Supreme Court, Senate, nobody has said that there's a matter before the Supreme Court. So let's say maybe the person didn't hear well, or he doesn't understand.
Oh,
So let's take our
that was
time.
not for you. That was for me. Because I had
No, so
asked the
let's
question on
explain.
the premise that the matter was already at the Supreme Court. So I was running it back to correct my question.
But I mean, I didn't answer it on the basis that the question, the case was in the Supreme Court. No,
Very
the
well.
motion is before the judge in the High Court. So he is requesting the judge. And the judge has to look and see whether, in actual fact, it should be sent. So Justice Kokuvite, in reading through, dismissed it. I said, no, I'm not sending it. The matters you've raised, I'm not sending it. So then I was also asking that even when it's sent, it takes a long time. They don't deal with that immediately. So we're just further explaining. Okay. Yes. So now to your new question. Yeah.
Right. So I'm asking, what are the options now post the sentencing?
Yeah. So a notice of appeal, and then he will be asking for bail pending appeal. Yes, the laws allow it. And that's why earlier on I said if you can demonstrate that the judge got it very wrong, then that is where he can get bail. But if he doesn't demonstrate that, he will continue to serve the sentence. Another option, which I see may well help him and which will support some time in the future, is when he asks for a rate, not in JM's administration, the next NDC administration, because 20 years by our laws, when they give you any term of imprisonment, generally, I'm doing the general rule so that there's no time for the exceptions. The general rule, you serve 2/3. So in this case, you do 20 divided by 3, and then you throw away 1/3. The remaining 2/3 is what you serve. So in this case, if you're doing 20 divided by 3, I think somewhere it will be 6 point something. Now, so you throw away one of the 6. So now he'll be doing a little above 13 years.
Right.
So above 13 years, that's what he should serve. Now, out of this 13 is still very long. So I support a case where maybe by 7 years, if it's any time between 5 and 7 years, if it's granted a pardon with the extra request that he should properly reclaim, apart from the penalty the judge has imposed, if you make available money for this proper reclamation, yes, between 5 and 7 years, if he's granted a pardon, it's fine. It's fine.
Yes. Now, I speak to my lawyer because I need a technical and I don't want to falter because I'm on for be a channel, so I don't want to misinform or miseducate people. He said that that's right. Wontumi eya appeal krana say a botia no man nyantum krana 15 years na de edanya wontumi betwa. Eno ni minimum. But oko prison for no matter years no matter years say oko them for a certain offense no. Oko them the president has the opportunity to give you a pardon. But I'm mostly some kind of parole system in America no. Ana element of ninja dem a pardon ebi nipa na pomudin baby akoduru. Ebi nipa no call prison no why good behavior or call your crane be a quality group be reforming prisoners so to omofo na ne ye bia no de wo fi ansa no de call one asasa. So all these circumstances will come to bear and any pan ebi so call you know the prison term near the man no so watcha bi or call no onkokonda. So all these things are there. But when it talks about the reclamation, that is something that I think that we need to do. And I'm surprised that most people didn't know about our laws. You see, the thing is that ignorance of the law is no excuse. In the MPP for no study, branch be framing. But you didn't go for not touching our parliament. 2019. But answer in I am kind to now because Asamuba. Anytime a pet court document and say asam na wote na bonten no dodo na enkoko to nkrata mu enti anye bu anya me pemanso anase asam na wate na wo kana me challenge you no me challenge you say ya mido ensam ni bebre no ne wote no abonten pa no na nse ya judge ba nko face one for case judge ni trimo de na amobi 20 anya judge no anya emra na wo ho ne say 15 to 25 to ma anything a year 20 he is in a balanced mood 15, 20, 25. Patrata, tenya judge, esa na mbara ne tie. Enye Wontumi ase anka anim say who instigate say obi emansa excavators. Oton excavator kwamo no do kwa galamsey 99.2B no ebo. Enti na people for be so start to say and then this for so bedem bankon phobia mo ye na ha because now they've become aware of the law. Say enyam yokoye galamsey no kra na ni ono no den amu minister mania so de na sase mo obi no 20 years. Enti na me ka say ne wo mramu ne de aya ye mfa mra ne nko ne yenyai mate say yesi we yesi we fa eko quarter sa nnema no ne o court doc fact no na e digina to gigeli obi pacho what ya say aha enti na me pe court facts na me the court na che say na court na ka na ma chechirem e the amount no. Now the second bit I also say is that some people have said that and their peer could be lost the case. I didn't want to go there. But you see, they na me ya semper video no, and I wish I don't know how to arrange this not to make it seem as if say there are some na make initially. Oh, you said it. I don't want to. I want a phrase to place it. But when you rewind the handset, I think about a month ago, and the appear could be quite simple. I want everybody to go and watch that video. I said it clearly. You see, me, I think that most people sometimes, I don't know why they do that, but I have this thing about me that when I'm watching somebody, see, what Andiapia could be dead. Let's not, they be I'm let's not approach issues with emotions. See, why you Wontumi lawyer? What in the chia? All 3 cases. In fact, I Wontumi very the on Tano first. Met them BB. Then I'm presented documents. Moka. Then I'm a Tano first. I'm a presented document. A child letter na Wontumi throw come out Western Regional Security Council. Only poor sign letter no. Sasemwe mon kaime 20th July 2026. One day be very useful. The demeanor of the lawyer and what he did was absolutely uncalled for. And then MPP for the social media. And I said that day, say, I don't know why the lawyer did that. Because you see, why would you be the client for somebody in a criminal matter, knowing full cognizance, say, at the end of 15 to 25 years? Listen, even fraud on there to Wontumi so in the Exim Bank case, it doesn't have such high years. You plead that one barely after 1-2 months the case was filed. In fact, that case near filing and if I'm forgetting, they need 3 weeks. If you bear me witness, they need 3 weeks on quiet or indicate this or bear plea bargain. It's in a brow course submission of no case. Mama click a link in a ready BDA. Say if you are being fair for when people know when this who can't law student to cry because law bro for never for one just a crack copy my charge PTO break it down for me layman terms or better was here. If you read the submission of no case 1, Oko appeals court and antentam and make them catch us a plea bargaining bill na you for ne go for them with the buy. The adene say you can only plea bargain before the judgment and won't you call court 10. I don't call no case my lord person you plea bargainer and one. The court is complete because that is not before, that is not after the judgment. So the plea bargain must always be before. It is an annual pay. The court on it 10. Now Wontumi call now so okay plea bargain and I raise all these issues. So for me, based on hindsight, it was sometimes to I saw damn it. But for me, when you read the submission of no case, and they are there. But you see, I'm not a lawyer, so I cannot give verdict on lawyer Andy Apiakubi. He's very respected. I mean, so them kind of respected Andy Apiakubi. I have enormous respect, but I think that in this matter, if not even the law, the public utterances, that particularly that Assemble FM interview was ill thought through. I think so. So that's why I'm commenting on the PR said. I feel that at that crucial moment and that interview, it sent a wrong signal. The wind was bad. It oozed some bad feeling. So that is what lawyer Martin Kpebu saying. 13 years because a 2 tests into 13 years 4 months. 13 years 4 months. So the 5-7 years. Now Bembiaba and then this Abayana also. Now say Obama presidential partner. I have no problem. But I agree Martin Kpebu that before that to happen, there must be restitution. In Sasia saying they must be restored. Every metal treatment, because there's a technology. May work Department of Physics and your professor back home. You can read about it and your friend Professor Kwachewa. There's this technology by the use of zeolite, Zeolite, to do some reclamation activities, and it works. They even have certain plants that they use. So those things, I'm amenable to them. And also I have no issue with somebody being punished though. But I always tell people that I'm a very emotive person. Man for see me in various, but I'm a very I have fellow feeling. I have feelings for people. I mean, and then I have feelings for people. And I knew the case. I mean, I've always said it. I just don't want to go into that matter, but I didn't expect that stretch. I expected maybe the minimum sentence and all that. But hey, the court has spoken, and I asked Madam Gertrude to say the law is the law. I'm not the law. I'm only a commentator. So, feel free share in the comments. You are not subscribed. Most subscribe and not click on the notification. The video will be able to be who knows much. Make sure also be shown to them. Ghana, see him. Bye bye.